Under Article 2, Section 4 of the United States Constitution, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Under Article 1, Section 3, Clause 7, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. And recently, Lawrence H. Tribe, Carl M. Loeb, University Professor Emeritus at Harvard University, wrote in an opinion editorial that was published by the Washington Post. To be sure, a former officer may no longer be removed even upon conviction by a 2/3 vote. But that has no bearing on whether such an ex-officer may be barred permanently from office upon being convicted. And it is the opinion of Professor Tribe that separate judgment would require no more than a simple majority vote. In U.S. v. Heard, a case decided in 2013 by the Fifth Circuit, the court stated that the illegal gratuity statute, Section 18 U.S. Code, Section 201C1, makes it a crime to be directly or indirectly give anything of value to any public official for or because of any official act performed or to be performed by such public official. And an illegal gratuity still requires a link between something of value and a specific official act. It is not enough that the gratuity was given because of the official's office. On February 10, 2016, at 7:59 a.m., an email transmitting a conditional offer of a position at the Defense Intelligence Agency was sent to a congressional candidate in Virginia's 8th Congressional District. According to Patricia Sullivan at the Washington Post, the Kingmaker Congressional District that has decided the outcome of statewide elections for the previous 2 decades. The thing of value for purposes of the federal bribery statute was a GG-13 grade position with compensation totaling $92,145 per year, including locality pay, or the equivalent of a stack of $1 bills measuring half the size of the White House. For purposes of the federal bribery statute, the congressional candidate is considered a public official because he had, on October 26, 2015, filed a registration with the Federal Elections Commission, which was acknowledged as received on November 6, 2015. The Hatch Act, as codified at 5 U.S.C. Section 7323A3, makes it a prohibited personnel practice for any federal employee to run for the nomination or as a candidate for election to a partisan political office, which would include Congress. Therefore, had the congressional candidate accepted the lucrative position with a prestigious national security agency, he would have been precluded under the Hatch Act from continuing in the race and would have been required in consequence to perform the official act of filing a withdrawal of his candidacy with the FEC. This fact pattern alone establishes a prima facie case beyond a reasonable doubt of an offer of an illegal gratuity, a misdemeanor under the United States Code that carries a punishment of a fine, imprisonment for up to 2 years, or both, which would not apply only to the offerer of the illegal gratuity, but also to the congressional candidate, had he accepted the job offer. More concerning facts about this criminal transaction is the fact that the deadline for the close of was set for the close of business on February 13, 2016, which fell on a Saturday. But far more disturbing is the fact that the deadline for candidates seeking to enter the Republican nomination convention was on February 12, 2016, the day before the deadline for the job offer. When the congressional candidate received the improper job offer, he chose to permit the deadline to simply pass. And under normal circumstances, a federal agency in a competitive selection would simply offer the position to the next qualified candidate for the position. But that did not occur in this instance. Rather, the congressional candidate was contacted once more by the agency, informed that the federal agency had not received his acceptance of the offer, and an accommodation extended the deadline for acceptance to February 29, 2020. Recognizing the impropriety of the second offer, the congressional candidate transmitted an email immediately to the agency to express his strenuous objections to what was a clear violation of law and a corruption of the federal civil service system, and meriting a whistleblower complaint for government waste, fraud, and abuse. In due diligence, the congressional candidate submitted a request for responsive documents under the Freedom of Information Act and Privacy Act, which under normal processing rules for federal agencies would be classified by an analyst as a non-complex request, simply requiring the agency to release a copy of the application materials and other related documents, as is generally done whenever a federal job applicant submits a FOIA request because of a suspicion of being denied employment because of discrimination. But this FOIA request was a little different because the complaint arose from an applicant who wished to know why the agency had offered him a job. And apparently, there was no application on file because none was returned in the FOIA request. And when the Department of Defense received the request, they issued a letter to inform the congressional candidate that they would not be able to comply with the normal response time of 30 days because of a backlog of FOIA requests at that agency, amounting to a mere 73 cases. The congressional candidate, who had formerly worked as a FOIA analyst with the Department of Homeland Security, which at the time had the largest backlog in the entire federal government, exceeding 45,000 open cases, found this reason for delay suspicious, a mere pretext, for under normal operations, a non-complex case could be expeditiously completed, and for internal control reporting purposes could actually accrue a benefit to the agency, having reduced the backlog at the Department of Defense a mere 73 cases, by at least one. With the assistance of Senator Mark Warner, the congressional candidate was able to expedite the response to the FOIA request, but only after Congressman Don Beyer, his incumbent member in Congress, had failed to respond to his request for assistance. It is of at least probative value that DIA is the headquarters for the Department of Defense Embassy and Consulate Services, DEX, which serves as the liaison office between the Department of Defense and the Department of State by representing DoD elements under the Chief of Mission and the Combatant Commands, authorities that use the International Cooperative Administrative Support Services Program. And Congressman Beyer had formerly served as the ambassador to Switzerland and Liechtenstein under Secretary of State Hillary Rodham Clinton, who during the 2016 election had been the Democrat Party nominee. It is of further probative value that when the congressional candidate had sought the assistance of Senator Tim Kaine, who had been former Secretary of State Clinton's running mate, he sent a very nice letter to indicate that under rules of professional courtesy, since the request for assistance had been submitted to Congressman Beyer, he did not wish to duplicate efforts and assured the congressional candidate that he was very confident that Congressman Beyer would respond eventually. In 2016, Had former Secretary of State Clinton been elected president, Congressman Breyer, as the heir apparent, would have been selected to replace Senator Kaine after he ascended to the office of vice president, according to the Washington Post. Congressman Breyer was the first member of the Virginia congressional delegation to demand an impeachment inquiry against former President Donald J. Trump. Beyond a reasonable doubt, included in the responsive documents received from DOD, there was what may be described as a deliberative process document, for it involved thoughtful review of various views on an issue, importing a policy reason in favor of the deliberative privilege to avoid chilling and distorting the candid discussion needed for optimum decision-making inside government agencies. Although there has been much dispute about the importance of protecting full and frank internal debate, many would agree that there are situations where such protection is important, according to the Department of Justice. But this responsive document that was released, despite an exemption from disclosure under FOIA Exemption 5, which generally protects from disclosure interagency or intra-agency memorandums or letters that would not be available by law to a party other than an agency in litigation with the agency, involved senior DOD officials at what appears to be the Defense Intelligence Agency, DIA, a 3-star billet, and the Deputy Chief of Staff for Intelligence, the DESIN, another 3-star billet, discussing an applicant who had decided to forego the offer. The remaining job applicants, including the congressional candidate, who had been determined to be qualified, and an internal consideration whether to extend a job offer for a mission that, curiously, had since expired, rather than to simply cancel the requisition. And further, a suggestion in the alternative for remedy to cancel the requisition, and if personnel were still required for some other mission, to republish the job announcement under new criteria. But that did not happen, and a job was offered for that expired mission to a candidate for which there is no evidence that there was ever a job application. The candid and frank discussion between senior officials at DIA and the DESIN at the Pentagon, both 3-star billet commands, are indicative of high-level discussions regarding the offer of an enviable position at a national security agency. And it would be just as concerning if former President Barack Obama or even Vice President Joe Biden was not aware of discussions at the Pentagon by 2 3-star billet commands. As stated by the court in U.S. v. Heard, the bribery statute, 18 U.S.C. Section 201B1, makes it a crime to directly or indirectly, corruptly give anything of value to any public official with intent to influence any official act. Bribery in requiring that the defendant intend to influence an official act therefore requires a quid pro quo, a specific intent to give or receive something of value in exchange for an official act. Courts have held, at least in the context of a conviction for honest services fraud through bribery, that if a quid pro quo is required, it is not required that the parties to the bribe have identified a particular official act, but only that the government prove the specific intent to give or receive something of value in exchange for an official act to be performed sometime in the future. An illegal gratuity, on the other hand, does not require a quid pro quo because it does not require the intent to influence any official act and can take the form of a reward for some future act that the public official will take and may already have determined to take, or for a past act that has already been taken. An illegal gratuity still requires a link between something of value and a specific official act. It is not enough that the gratuity was given because of the official's office. in U.S. v. Heard, a contractor was convicted of both bribery and offering an illegal gratuity for simply offering a free golf trip to a government official. 5 U.S.C. Section 1221F3 provides that if based on evidence presented to it under this section, the Merit Systems Protections Board determines that there is reason to believe that a current employee may have committed a prohibited personnel practice, the board shall mandatorily refer the matter to the special counsel to investigate and take appropriate action under Section 1215. This is the whistleblower provision. However, to date, despite a complaint filed with MSPB, no investigation has been commenced. Rather, prior to leaving office, former President Obama permitted the former members of the board to resign, one by one, leaving the adjudicative agency without a quorum to decide petitions for review of that agency's preliminary decisions, resulting in not only a large backlog of cases, but to date, the longest lack of a quorum in history, exceeding 4 years. An extraordinary occurrence, because prior to this instance, any lack of a quorum had been resolved in under a month. The sole remaining member of the board, Mark Robbins, now the chief counsel for OPM, serving as acting chairman then on May 11, 2018, issued a withdrawal policy under the pretext that it was a measure to address the growing backlog and to provide those awaiting final adjudication of their appeals to request a withdrawal in exchange for a final order as the complainants were informed they could present to a court, but without expressing which court. The withdrawal policy did not specify which court because no reviewing court under Federal Rule of Appellate Procedure 60 reviews any final order except for an occurrence of adverse action to that appellant. And if an appellant had specifically requested a withdrawal from an agency, were it granted to them, that would not be adverse to them, indicating that the withdrawal policy is essentially a fraudulent inducement to complainants to forfeit their appeals of right. Indicia supporting a finding of bad faith include the fact that the withdrawal policy was coincidentally issued on the same day that it acknowledged receipt of the congressional candidate's petition for review. It was offered immediately after to the congressional candidate to utilize to resolve his complaint, and it was issued without the mandatory 60-day comment period, as required by law. This matter has been the subject of 3 litigations in federal courts, and has also given rise to a specific request for repeal of the withdrawal policy that was submitted by the congressional candidate. But the withdrawal policy still stands, and the case awaits adjudication by the board at whatever time the lack of quorum has finally ended, to hand down a decision as to whether or not the whistleblower complaint that under 5 U.S.C. Section 1221F3 should have been commenced immediately will ever begin, perhaps sometime after the pandemic. The official position taken by the Merit Systems Protections Board attorneys in court was that anyone would have accepted such a wonderful job opportunity, and that it was very, very surprising that the congressional candidate might contest this transaction in court. This advertisement was authorized by Mike Webb.